Hi everyone. I have become aware that the next of kin and relatives of patients in hospital, particularly those who are being treated for COVID-19, are being denied access to information on the medication and medical treatment being administered to their relatives or loved ones, with the argument being advanced by medical professionals that it is confidential information. The purpose of this video is to review 3 pieces of Irish law that may assist you should you encounter this situation, and to explain to you the limitations regarding next of kin legal status and powers of attorney when it comes to making healthcare decisions on behalf of another person. Before we get into the law around powers of attorney, you need to be aware that the term next of kin is not a legal term. It is used in medical or healthcare settings to simply indicate the person you would like to be contacted in the event that something happens to you, such as an accident or illness. The person stated to be your next of kin does not have any legal authority or responsibility to make decisions or give consent on your behalf unless they have been legally appointed to do so under a power of attorney, a registered enduring power of attorney, or an advanced healthcare directive. In 2018, Sage Advocacy commissioned a survey which found that 52% of those questioned believed that anybody named as a next of kin could make healthcare or other major decisions on behalf of another person. The importance of understanding the law in this area cannot be overestimated. In this video, we will review the law around 1. An ordinary power of attorney, 2. An enduring power of attorney, and 3. An advanced healthcare directive. So we will start with an ordinary power of attorney. The relevant law in this area is the Powers of Attorney Act 1996. A power of attorney is a legal instrument that can be created by a person, usually called the donor, to allow another specifically appointed person, usually called the attorney, to take actions on the donor's behalf if he or she is absent, abroad, or incapacitated through illness. There are 2 types of power of attorney, an ordinary power of attorney and an enduring power of attorney. In this section, we will review ordinary powers of attorney. An ordinary power of attorney can be either specific, so limited to a particular purpose like selling a house, or general, meaning the attorney can do anything that you yourself can do. It is important to note that an ordinary power of attorney ceases if the donor becomes mentally incapacitated. A general power of attorney allows the attorney to take a wide range of actions on the donor's behalf in relation to property, business and financial affairs, but not healthcare decisions. Section 15 of the Powers of Attorney Act 1996 confirms that you are not required to engage a solicitor to create an ordinary power of attorney. That said, because a power of attorney is an important legal document with potentially serious legal and financial consequences, it would be prudent to seek legal advice to ensure you understand the full implications of what you are agreeing to. An ordinary power of attorney can be created when signed by either you or at your direction and in the presence of a witness. Note that an ordinary power of attorney is not valid if it is not signed in the presence of a witness. The donor can appoint anyone he or she wishes to be their attorney, including a spouse, family member or friend. Section 21 of the Powers of Attorney Act confirms that in order to prove the validity of an ordinary power of attorney, you must either produce the original document or a copy certified by the donor or a solicitor who must confirm that it is a true copy of the original. A template form for an ordinary power of attorney is included at the 3rd schedule to the Powers of Attorney Act 1996. You can use this as a template should you wish. I've included a link in the description box of this video of the template contained in this act. That said, we have also prepared our own template ordinary power of attorney that you may use as a starting point. My strong advice is to consult with a solicitor before signing any power of attorney to make sure that it is appropriate to your situation and also to make sure that it is enforceable. The main query I would raise with your solicitor is the possibility of including a provision in the power of attorney stating that should you end up in hospital, your attorney would have access to 1. All information concerning your medical condition, 2. Full details of all treatments under consideration, and 3. Full details of any medication that you may be placed on. As stated previously, an ordinary power of attorney cannot authorise the attorney to make healthcare decisions on your behalf, but it may be possible to include a provision whereby the attorney has access to information on your healthcare. One of the most important points to note is that an ordinary power of attorney is no longer valid if you become mentally incapacitated. In this case, you must also have in place an enduring power of attorney and advanced healthcare directive. It should also be noted that you can withdraw an ordinary power of attorney at any time. The second area of law that we will look at is enduring powers of attorney. The relevant law in this area is the Powers of Attorney Act 1996, Statutory Instrument 196 of 1996 and Statutory Instrument 287 of 1996. It's also worth noting that Part 7 of the Assisted Decision-Making Capacity Act 2015 provides for new arrangements for those who wish to create an enduring power of attorney. However, this Part 7 has not been commenced yet, so the 1996 Act continues to apply until such time as Part 7 is commenced. It has been said that the 2015 Act will be fully commenced this year, 2022, and if or once that happens, no new enduring powers of attorney will be able to be made under the 1996 Act, but any enduring powers of attorney correctly created under the 1996 Act will remain valid. You can only create an enduring power of attorney while you have mental capacity, and it only takes effect if or when you become mentally incapacitated and are no longer able to manage your own affairs. An enduring power of attorney can give general authority to do specific acts on the donor's behalf in relation to financial matters, noting that if you give the attorney general power in relation to your property and affairs, they will be able to deal with your money and property as they think fit, which may include selling your home. That said, you can include restrictions in the enduring power of attorney, setting out actions that your attorney cannot undertake. One of the main points to note about an enduring power of attorney is that the attorney can also be given the authority to make certain personal care decisions on your behalf, provided those decisions are made in your best interest. It should, however, be noted that personal care decisions are not healthcare decisions. According to the 1996 Act, a personal care decision might include where and with whom you should live, who you should see and not see, what training and rehabilitation you should get, your diet and dress, inspection of your personal papers, housing, social welfare and other benefits. Again, the important thing to note is that the list does not include healthcare decisions, which we will discuss under the section Advanced Healthcare Directives. The procedure for creating an enduring power of attorney is more complex than that for creating an ordinary power of attorney, and you have to use both a solicitor and a doctor to complete the process, which can make the process expensive and therefore acts as a deterrent to many. The document creating the enduring power of attorney must be in a particular format and must include the following. 1. A statement from you that you understand the effect of creating the power. 2. A statement by a doctor verifying that in their opinion you had the mental capacity at the time that the document was executed to understand the effect of creating the power. 3. A statement from a solicitor that they are satisfied that you understand the effect of creating the power of attorney. 4. A statement from a solicitor that you are not acting under undue influence. 5. A statement by your chosen attorney or attorneys that they understand their obligations and agree to be an attorney. Also, at least 2 people in addition to the attorney must be notified of the making of the enduring power of attorney. Also, certain people cannot be appointed as your attorney, including people under the age of 18, bankrupts, people convicted of offences including fraud or dishonesty, people convicted of an offence against you, people disqualified under the Company Acts, an individual or trust corporation who owns a nursing home in which you live, or an employee or agent of the owner, unless that person is also your spouse, civil partner, child or sibling. The final point to note about an enduring power of attorney is the fact that it must be registered with the court. In order to register an enduring power of attorney, the future attorney makes an application for registration to the Registrar of Wards of Court once there is reason to believe that you have become or are becoming mentally incapacitated. The attorney must have a medical certificate confirming that you are incapable of managing your affairs. Also, the donor, if mentally capable, can revoke an enduring power of attorney at any time before it's registered with the court. Once an enduring power of attorney has been registered, it cannot be revoked even if you are for the time being mentally capable, unless you make an application to the court. The third and final area that we will look at is advanced healthcare directives. The relevant law in this area is Part 8 of the Assisted Decision-Making Capacity Act 2015. Noting also that this Part 8 has not been commenced yet, but as stated earlier, the government have confirmed that all sections of the 2015 Act will be commenced this year. However, it's worth noting that advanced healthcare directives are currently recognised in common law in the courts of Ireland, so you can still put in place an advanced healthcare directive while waiting for Part 8 of the Act to be commenced. That said, most of the information that I will provide in this section has been taken specifically from Part 8, and it would be my strong advice to follow the rules set out in this Part 8, as I expect that any advanced healthcare directive made is more likely to be enforceable if it follows these rules. Most people seem to be under the impression that an ordinary power of attorney can be created to authorise another person to make healthcare decisions on your behalf if or when you become incapacitated. This is not the case. That's why it's so important to understand the benefits of putting in place an advanced healthcare directive. An advanced healthcare directive is a document that allows you to make a statement on the type of medical or surgical treatment that you do not want if you are unable to make those decisions into the future. It only comes into force if you lose capacity and are no longer able to communicate your own decisions. An advanced healthcare directive provides direction to healthcare professionals to care for you according to your specified wishes, and provides clarity to family members about the care you want or don't want to receive. An advanced healthcare directive is a legally binding document where you write down what healthcare treatments you do not want in the future. For example, some people make a directive to limit the treatment in order not to prolong life, such as a do not resuscitate order. You can also write down what treatments you would like to receive, but that is not legally binding. So, for example, if you stated that you wanted to receive ivermectin if you were hospitalised for COVID-19, this would not be legally binding. But if you stated that you did not want to be put on a ventilator if hospitalised for COVID-19, this could be legally binding. That said, any treatment you request in your statement must be taken into consideration if it is relevant to your medical condition. It's important to note that if your statement does not address the exact circumstances you face, it may not be enforced. It should also be noted that your statement will not be enforced if it specifies doing something illegal. As part of the directive, you can nominate a designated healthcare representative who will be legally recognised as acting on your behalf if you lose capacity, and they can ensure your advanced healthcare directive is enforced. You can appoint anyone to be your designated healthcare representative, with a few notable exceptions, such as persons under the age of 18 years, a person who has been convicted of an offence in relation to your or your child's person or property, a person against whom you or your child has a safety or barring order. There are a few other exceptions in addition to the above noted in Section 87 of the 2015 Act. According to the 2015 Act, an advanced healthcare directive must include the following. 1. The name, date of birth and contact details of the person making the statement. 2. The signature of the person making the statement and the date of signature. 3. The name, date of birth and contact details of the person you select to be your designated healthcare representative, if any. 4. The signature of the designated healthcare representative, if any, and the date of their signature. And 5. The signatures of 2 witnesses. Section 88 of the 2015 Act sets out exactly what a designated healthcare representative can do and provides that they may be given power in relation to one or both of the following. 1. The power to advise and interpret what your will and preferences are regarding medical or surgical treatments by reference to your advanced healthcare directive. And 2. The power to consent to or refuse treatment up to and including life-sustaining treatment based on your known will and preferences by reference to your advanced healthcare directive. If you decide that you want to put in place an advanced healthcare directive, I would strongly advise that you consult with a solicitor to ensure that it's enforceable and also to ensure you understand the powers that you are giving to another person should you become incapacitated. So, to recap, with respect to next of kin, 1. It is not a legal term. 2. It simply means a contact person in case of emergency. And 3. The person who is your next of kin has no legal authority to make decisions or give consent on your behalf. With respect to ordinary powers of attorney, 1. They can be specific, so limited to a particular purpose like selling a house. Or 2. They can be general, meaning the attorney can do anything that you yourself can do. 3. They can only be created while you have mental capacity. 4. It ceases to be effective once you lose mental capacity. 5. It only applies to property, business and financial affairs. 6. It does not apply to healthcare decisions. 7. You do not need to engage a solicitor to create an ordinary power of attorney. 8. It must be signed by you and in the presence of a witness. And 9. Only the original or a certified copy of the original can be used to prove validity. With respect to enduring powers of attorney, 1. It can give general authority to do specific acts in relation to financial, property, business and personal care matters. 2. It does not apply to healthcare decisions. 3. You can include restrictions to stop the attorney being able to do certain things like sell your home. 4. It can only be created while you have mental capacity. 5. It only comes into effect once you lose mental capacity. 6. You must engage a solicitor to create an enduring power of attorney. 7. It must be registered with the Wards of Court's office to be enforceable. And 8. It can be revoked at any time before it is registered, but can only be revoked through court application once registered. With respect to advanced healthcare directives, 1. It is a statement on the type of medical or surgical treatment you do not want. 2. It only comes into force if you lose capacity. 3. You can write down what treatments you would like to receive, but this may not be legally binding on your doctors. 4. The statement cannot be enforced if it specifies doing something illegal. 5. You can nominate a designated healthcare representative who will be legally recognised as acting on your behalf if you lose capacity and who can ensure your advanced healthcare directive is enforced. 6. You can authorise your designated healthcare professional to A. Advise and interpret what your preferences are by reference to your advanced healthcare directive, and or B. Give them the power to consent to or refuse treatment based on your preferences by reference to your advanced healthcare directive. And 7. The 2015 Act confirms that an advanced healthcare directive will only be binding if it contains certain information. In the description box of this video, I have included some further links so you can carry out some further research into this important area. Thanks for listening.